Bill Chatt and Joshua Rosenzweig back with the Cervantes Chatt and Prince Legal Minute. We have been talking estate planning and probate. Last episode, we just gave a really 30,000-foot view of estate planning documents. Again, these conversations are moving along with the assumption we're talking about an estate of under $4 million because that's a tax threshold at which inheritance tax kicks in. So we're talking for estates under that. So again, just to recap, the last time we talked about TOTI real quick. We talked about a small estate affidavit, but what we're really going to start rolling out now is our typical estate plan, which is going to be powers of attorney for healthcare and real estate, a pour-over will, and trust. Mm-hmm. And so what we're going to try to tackle right now are powers of attorney. Now, let's start with one thing. There's powers of attorney. There's also what is known as living wills, correct?
Correct.
And the difference between the way those work.
So the way that I understand the difference between powers of attorney and living wills is that powers of attorney provide your agent, because when you sign a power of attorney, you nominate and appoint somebody to make healthcare and or financial decisions for you. You're giving them the ability to actually make a decision. You're telling them in the POA for healthcare, for example, when it comes to life-sustaining treatment, whether you want them to pull the plug immediately or you want them to take into account the prognosis, what the doctor says, the cost, the quality of life, and giving an agent the ability to make a decision. With living wills, it's not really a decision for the person you identify to employ the directive. You're giving them the directive, and there's no decision for them to make. I've always been a bigger fan of giving somebody who's competent, might be emotionally charged, sure, but also usually when we appoint somebody as our agents, we're appointing somebody who we quite literally trust our lives with. And so that person usually has a pretty good understanding of what our wishes are. And so for that reason, I'm more inclined to use a power of attorney for both healthcare and for property in my estate planning than I am living will.
Yeah, and a living will might be fine for, like, say, the single person who really has no family left at that point in life. Or, I don't know about you, but I've had it where you're talking to the couple about how power of attorney for healthcare works, and the one's like, oh, I don't know if I could pull the plug and things like that. And and then you could, because don't forget, like, when you're working with your attorney, you as one spouse have your wishes and things like that, and the other one does too. So we have this duality here where we're dealing with two sets of people. So if you're kind of like, hey, don't leave me hanging, you may say, all right, you know what? I don't like this. I'm going to do a living will. I haven't had that. And the thing too is, I don't know about you, I've never had to litigate these things. I've never had to go to court. And, those are the things you see in the news.
No, I think thankfully I haven't had to litigate one of them. But this goes back to, one of our kind of core principles around here is communication.
Right.
And so when you have a husband and wife or husband and husband, whatever the couple is that's in front of you, I think it's important to have conversations with the parties and individuals.
Right.
Because you might not want to hurt your spouse's feelings by saying something in front of them about what you want or what you won't do. But you might feel comfortable saying it to me with the spouse out of the room. Right. As silly as that sounds,
right?
It's happened before. Mm-hmm. And so you make sure that everybody is on the same page, because then what we try and do is, after I hear that and I put the documents together, we're going to have a group meeting. Right? We're going to talk about what everybody's wishes are so that nobody is surprised when the time comes. And this is a little bit off topic, but again, it's always making sure that communication is there when we're making these decisions. Because again, if you're slapping a paper down in front of someone and saying, your spouse is about to go, what do you want us to do? Having not had the conversation beforehand to understand exactly what they want can be a really daunting task.
Yeah, and that what is supposed to happen with the power of attorney for healthcare or the living will is that, when that time comes and you're at you're speaking with a doctor, you're at a medical institution, they're going to say, do you have that? Now, I've my own personal experience. They don't always ask for that. They kind of look for the person in charge.
Right.
But it is also for their protection too, so that they know that they're taking the records. So that's why you want to make sure you keep that documents when we give them to you
Yep.
because you may need them. Ostensibly, you should need them eventually. So, they deal with the same topics. One handles it a different way. One bypasses an agent and then gives discretion, like you said. So that's the healthcare one. The property one, which is the same one we use for real estate transactions sometimes when one spouse cannot be at a closing, right?
Right.
These are statutory forms. They literally come from the Illinois Legislative Code, like the property. And so you've got all these different powers that the agent is given. And we'll post PDFs of this that you can kind of access. So it's the same one we use for real estate. And so it's got, you can undertake a real estate transaction, stocks and bonds, taxes, safety deposits, blah, blah, blah. And what that is, again...
And the catch-all, all other property and or financial matters.
Right. And so what the thing is you can go around town and say, hey, I need to get in the safety deposit box. I need to make a deposit. I need to withdraw money. That's what the thing is for. I want to make sure we don't lose this point. In both instances, in the healthcare and the one for property, you did while you were living, actually. Right. So even though they're part of your estate plan, once the person who gave the power of attorney passes, we do not rely on them any longer.
Correct.
But I tell my people that I do the estate planning for, so that power of attorney for real estate may have some implications now in the event like you sell the house in 2 years and you're out of the country and we need paperwork signed. Now a lot of banks will be like, hey, this thing's 4 years old. We want a new one. And again, the people making the rules get to do that, even though it's valid.
Right. If it's effective when you execute it, meaning then it's properly executed, and in Illinois, a power of attorney for property requires the principal to sign it, one disinterested witness, and one notary. POA for healthcare is just the principal and a witness. No notary is required. It's supposed to be effective, even if the form has changed down the road. Similar to as we talked about a little bit ago with the small state affidavit, though, you find that there are times where people are reluctant to accept them. I can remember when my wife and I were refinancing our house. I am her agent under the power of attorney for property, and the bank would not accept my POA that I had for her and made us sign a new one, which was the exact same form, because it crossed out all the other things that I'm able to do, which still seemed kind of silly because I still had the authority to do it.
And then I might have crossed that one too, because I always tell people leave it wide open, because arguably a real estate transaction is a lot of things, right? You're signing a 1099. That's a tax form, right? Banking transactions. Where are we going to deposit the money? So I just don't need a title examiner going, you can't do this, right? So I just tell them to leave it wide open.
Right.
One thing I also want to catch on is, just so you know, we're talking about Illinois statutory power of attorney. States have their own form. Now, if you were to move to Nevada and you had your powers of attorney from Illinois, they'll look at them and they would interpret it under Illinois law.
Right.
Vice versa, if you're coming into the state of Illinois and you say, hey, we just had an estate plan down in North Carolina. Right. Doesn't mean we have to redo it. We want to make sure it's compliant with North Carolina law, that we did it right.
Correct.
Because the Illinois court will go, the main thing is like witnesses, like on the power of attorney.
It's got to be properly executed.
Correct.
If it's properly executed in this state, it's supposed to be valid in any other state. Similarly, if it's properly executed in Nevada and it's used here, it's supposed to be recognized here as a valid POA.
Right. So those powers of the powers of attorney in the context of your estate plan, there's going to be while, I guess let's just put it this way, at end of life, right? You're still alive, but maybe one spouse needs more care, so we're gonna downsize the house, move to a smaller house, things like that. Well, they can't. First of all, maybe they're not even mentally able to understand it. That power of attorney is gonna be fine, right? Because when we do it in the estate plan, it's going to be effective on execution, and it's going to terminate upon death. In real estate, the only difference we would do one for real estate, we'd say it terminates upon the closing of the transaction, right? You don't want that hanging open. Right. So that'd be the difference. Even though it's the same form, we would change that clause. So again, we're going to be using these powers of attorney while we're making some important decisions while the person's still alive. Whether or not to sell the house, whether or not to withdraw money, move it from one fund to another, whatever that is.
Right. And sometimes, realize that the power of attorney for property in a real estate transaction is also going to be used for convenience purposes. process.
Yep.
Right? Because that person may be bedridden, the owner. They may not have the ability to sign their name to 37 closing documents.
Right.
And that's why you have the agent come in to do so.
Right.
Right. So that's a part of it as well. And the power of attorney for property, remember, aside from saying it'll be effective only until this transaction is closed, you can actually put a date.
Correct.
So one of the reasons that people might want a POA for property is simply they're going out of the country and they need somebody to look over their affairs while they're away. But when they get back, they want it done.
Yeah.
And they don't want the person to have that authority. You can put a 2-month date on it, and then it becomes ineffective.
Yeah, and that is the way to do it, because I've had some people come to me and they have changed title. I said, why did you change title? Which, by the way, you can't just do that without asking the mortgage company. I've had someone put their son on it. It's like, you can't do that, right? You're not supposed to do that. Well, they were out of the country, and I'm like, there's better ways of dealing with that,
Yes.
which you pointed out is the power of attorney. So again, those 2 documents are going to be working together while the person is alive. And then the final piece that I was just going to say about the estate plan is we're going to ask you, if you've got a pension, if you've got a 401k, if you have any type of account, CDs, things like that, we want to make sure that if you've got a beneficiary form, that you've got the beneficiaries. They don't have to be part of the will or the trust. 401k, right? And so, and again, that is sometimes it affects the taxable value of the estate. But we want to make sure that your beneficiary forms are filled out. Right? And so we would ask that as one of the final steps to make sure that your estate plan is together. So, right. All right, that's it for powers of attorney. Thanks for listening, and we'll see you the next time.